Welcome to a Bite-Size HIPAA Q&A video where we answer your questions about how HIPAA applies to your dental practice. We recently received the following question in our inbox. The writer says, I've always trained our staff that if a school calls and asks for confirmation about a patient appointment, that we cannot answer it due to HIPAA. Giving a school release note directly to the patient isn't an issue because they can give that note directly to the school and we are still in compliance. However, when the school calls directly and asks for confirmation that the student is a patient of ours and had an appointment on a specific date, that is not information we can confirm. This happened recently. A school called asking for confirmation, and when we refused to disclose the information, the school administrator was very adamant that she was entitled to the information and said they were not subject to HIPAA. I'm almost sure we handled this situation correctly, but just in case, can you please provide some clarification? Well, first off, thank you for your question, and thank you for being proactive with your staff privacy training. Let's see how the HIPAA law would specifically relate to the question about disclosing appointment details to a patient's school. Our first step is always to ask if the information requested is considered protected health information. Here the answer is clearly yes. The patient's name, along with any details regarding an appointment or treatment, are indeed considered PHI, so HIPAA is applicable. Next, let's figure out if HIPAA allows the disclosure. Remember, our basic rule is that you cannot disclose PHI without patient authorization unless there is a specific permitted disclosure rule that applies. The most common permitted disclosures are disclosures for treatment purposes, billing purposes, and healthcare operations, so let's look there first. Is the purpose of this disclosure for patient treatment? No. Billing? No. Healthcare operations? No again. And since those three exceptions don't apply, we will likely need patient authorization to disclose the information to the school. But let's keep digging a little deeper into the four other categories of permitted disclosures. There we'll find buried in the list of permitted disclosures for public health purposes an exception that seemingly says providers can disclose PHI about a student to a school. But the next few lines limit this exception to only apply to immunization status, and it still requires the student or parent to agree to the disclosure. So the one exception targeted at schools doesn't apply to this situation. Now, the question also mentioned that the school administrator requesting the information said that HIPAA didn't apply to them because they're a school. Remember that HIPAA law only applies to covered entities. A dental office is a covered entity, but a school is not. So the school admin is right. Schools are not held accountable to the HIPAA law when it comes to the privacy and security of their students. They have their own set of federal standards and regulations, but not HIPAA. However, as a covered entity, you are still required to comply with HIPAA for every disclosure of PHI. So, to answer the writer's question, yes, you handled the situation correctly. You are not allowed to disclose a patient's name to a school or confirm whether a student is a patient or had an appointment. This is all protected health information and cannot be disclosed to a school without written permission from the patient or their guardian. You are allowed to provide a doctor's note to the patient that the patient can then give to the school. Great work. If you have a HIPAA question related to the day-to-day operations of your dental practice, feel free to send it my way. My email address is todd@bitesizehipaa.com. That's 1 P and 2 A's. I can't promise that I'll be able to get to every question submitted, but I'll do my best to find the most applicable ones to address in future Bite-Size HIPAA Q&As.